I stand on established protocol. A pleasant good morning to all. My name is Samuel Campbell, as Ms. Nottage said. I'm a financial and trade officer in the Ministry of Financial Services, Trade Industry, and Immigration. This next panel on the legislative agenda will feature a presentation by a seasoned ADR practitioner, Ms. Lashley, and the arbitration consultant in the ministry, Ms. Theominique Nottage, on the revamping of the ADR legislative framework and the proposed new legislation that the ministry hopes to advance over the next 2 years. I am happy to introduce our first speaker for this panel, Ms. Lashley. Ms. Lashley is a barrister of more than 40 years standing with experience in litigation, family, corporate, employment, and trust matters. A fellow of the Chartered Institute of Arbitrators, she is proficient both as an arbitrator and a mediator, where she's undertaken numerous training courses over the years. Having been designated by the Bahamas government to serve on the panel of arbitrators and of conciliators, Ms. Lashley was redesignated to serve for the next 6 years. Her professional memberships include FIDA, the International Federation of Women Lawyers, the Society of Trust and Estate Practitioners, or STEP, Mediators Beyond Borders International, Mediate.com, Mediator Academy, the International Bar Association, the Bahamas Bar Association, where she is currently chairperson of the ADR committee of the association, and a fellow of the Chartered Institute of Arbitrators since 2012. In addition to her professional memberships, Ms. Lashley is also heavily involved in a number of civic organizations. Determined to encourage, educate, and strive for peaceful and amicable resolutions to conflict, in 2016, she founded ADR Bahamas to provide education and stimulation for non-violent communication and conduct, and provide neutrals to facilitate conflict resolution. I have seen firsthand that she has been a strong and persistent advocate for advancing legislation reform in ADR.
This segment is presented by myself and Theominique Nottage, who's been introduced already. And in the interest of time, we're going to just very quickly go through the course to be charted by the Bahamas in the next 2 years. The CJ has spoken very aptly about the arbitration being an adjunct to the court system. And our Arbitration Act of 2009 will, over the course of this next year, be renamed the Bahamas Domestic Arbitration Act to govern all domestic arbitration. As such, there are only very, very minor adjustments to be made so that our act will be consistent with best practices globally. And as the CJ spoke about the impending changes to the civil procedure rules, that will also ensure that we're consistent with those new, soon to be implemented rules. The 2018 Commercial International Arbitration Bill has two main features. One, it incorporates the UNCITRAL model law. And of course, that will make the Bahamas much more attractive to large multinational enterprises as an arbitral seat when it is an UNCITRAL model law jurisdiction. And the other feature is the PCA, the Permanent Court of Arbitration in The Hague. We already have a relationship with the Permanent Court, having been established as a member. And with this bill, which has been presented, the Bahamas will become a cutting-edge jurisdiction, and it will complement the existing vibrant industries that we have, in particular, financial services and tourism. The bill as presented will have very few amendments to be made to, again, ensure consistency with the international regime and with our government's policy. The domestic mediation bill, I'll go on to next, will facilitate a cost-effective means for parties to secure their own best interests and determine their own framework for settlement. We have heard that from the CJ again that this will soon be an integral part of the new CPR rules, which we hope to see before Easter. The domestic bill sets out principles applicable to mediation. It sets out also the provision of codes of practice for mediation practitioners. And it sets out examples of how the process should be undertaken. It shows as well how the mediator controls the process. This bill will have regulations referring entirely to codes of practice for attorneys, for mediators. And these codes of practice will relate also to training of mediators, training of attorneys as representatives for parties, the role of the court, and ethics and standards in the mediation process of those practicing. The International Mediation Bill will provide for mediations, settlement agreements in those mediations, which will be enforced as an order of the court. This bill is consistent with the UNCITRAL model law on international commercial mediation and international settlement agreements resulting from mediation. And it will incorporate the Singapore Convention on Mediation. So all we'll have to do is sign on to the Singapore Convention. Everybody here on this panel, both on the panel and listening, will be relatively familiar with both the mediation and arbitration component of the legislation. The construction adjudication bill is less well known in our jurisdiction, but quite a bit of work has gone into it, and it's a form of dispute resolution that allows parties to get a decision on construction projects without long, expensive court proceedings. And so the bill will establish mechanisms to resolve construction disputes. However, this will be during the course of the construction, and the dispute will be on an interim basis. So the bill will have the exact same features of the other proposed legislation: confidentiality, neutral and impartial professionals, and the obligation of the professionals in terms of standards, training, neutrality. Some of the advantages of construction adjudication are that the disputes will be dealt with and resolved as they arise quickly and at not very much cost, because it will only deal with the specific topic that has posed a problem that might stop the work, whether that problem will be a defect in work, disruption of a delay in the process, a purported breach of contract. And so the adjudication will deal with that claim only, and a specific time frame will be provided for that claim to be adjudication to be dealt with, so the construction of the project can continue and move on. And so I will now turn the matter over to my colleague Theominique, who's going to talk a little bit about the timeline and conclude this segment. Thank you.
So I wanted to talk about the timeline very briefly. Over the course of the next 2 years, we plan to enact 5 pieces of legislation. We recognize that this is a very ambitious plan and it's a lot to be done over the course of the next 2 years, but we're confident that we're going to be able to get this done, as all of these bills are already in their draft forms. They just require public consultations and finalization by the Law Reform Commission and sign off by the Office of the Attorney General. So in 2021, we plan to enact the International Commercial Arbitration Bill 2018 with the suggested amendments that have been already provided by industry. Again, I want to confirm that we will circulate through the Bahamas Bar Association, Chamber of Commerce, and other relevant organizations the bill for public consultations before it moves to Parliament. We're also going to amend the Bahamas Domestic Arbitration Act to make sure it is consistent, as Mrs. Lashley already indicated, with the civil procedure rules and with international best standards. So in addition to those 2 acts, we do have a number of other initiatives that we plan on accomplishing in 2021. One of those initiatives was this ADR symposium to reintroduce what we're doing at the ministry to the Bahamian public and to persons internationally. We do plan to establish a clear policy statement in relation to the Permanent Court of Arbitration and further strengthen that relationship with the appointment of members of court. That should be done this year. We plan to reintroduce the International Commercial Arbitration Executive Council of the Bahamas as an alternative dispute resolution council. So we also have persons from industry, from the public sector and the private sector as part of the decision-making process as we go through establishing the ADR legislative framework. And we are also looking at the review of different policies in relation to ADR, for example, the investment treaty policies, et cetera. And we are also planning to strengthen our relationships with our strategic partners who were represented in the role of the panel of industry stakeholders. Many of our strategic partners, BFSB, CARB, AIBT, Bahamas Bar Association, Chamber of Commerce, et cetera. And in 2022, we are focusing on the mediation bills, that is to say the International Mediation Bill and the Domestic Mediation Bill, and also construction adjudication, because those bills will take more time to educate the public on. And I want to emphasize, as Mrs. Lashley's already said, that the ministry is committed to engaging with the public on these pieces of legislation and making sure that everybody is in agreement with what we propose to be the law that governs the ADR regime in the Bahamas. So again, in conclusion, we have 5 pieces of legislation that we're going to focus on over the course of the next 2 years. We are going to have public consultations on each of the pieces of legislation, and we consider that at the conclusion of the 2 years, the suite of ADR legislation will be transformative for the dispute resolution industry in the Bahamas as it presently stands. With that being said, Mrs. Lashley and I will conclude this panel on the legislative agenda, and I will turn it back to Sammy to moderate the final panel.